Welcome to the Federal Court's first in a series of 3 webinars marking our 50th anniversary. My name is Alan Diner. Le sujet de cette première séance est le droit de l'immigration et nous allons entendre 3 conférenciers exceptionnels qui ont tous une grande expertise dans l'un des domaines de travail les plus occupés, dynamiques et d'actualité des cours fédérales. Je vais vous laisser lire leur biographie complète, mais permettez-moi de dire quelques mots sur chacun. Tout d'abord, le professeur Martine Valois de la Faculté de droit de l'Université de Montréal nous donnera un aperçu du chapitre sur l'immigration qu'elle a rédigé pour notre livre du 50e anniversaire lancé plus tôt ce mois-ci, incluant l'incidence de notre jurisprudence sur le droit canadien et international. Ensuite, la juge Mary Gleason, qui a rédigé plusieurs décisions influentes en matière d'immigration, tant à la Cour fédérale, comme Rahal et Portillo, qu'à la Cour d'appel fédérale, avec des décisions comme Lewis et Ishak. Le juge Gleason parlera du rôle de la Cour d'appel fédérale dans les affaires d'immigration et de la jurisprudence concernant les questions certifiées. Enfin, Lorne Waldman est un chef de file de longue date dans la section nationale du droit de l'immigration, un expert de renommée internationale qui a plaidé de nombreuses causes et qui a acquis une grande reconnaissance, incluant l'Ordre du Canada. M. Waldman conclura avec ses observations sur les questions de droit non réglées. Chaque expert parlera pendant 15 minutes, puis il y aura une période de questions interactives de 30 minutes. Je vous encourage à poser des questions aux conférenciers et je vous également encourage à lire leurs articles. Chacun est excellent. Avant d'écouter nos 3 panélistes, on m'a demandé de faire quelques observations préliminaires. Since their earliest arrival in contact with Indigenous people, immigrants have had a transformative effect on Canada. Over the centuries, immigrants have helped to establish and build the country around us. We have been an engine of change and transformation, though we still have much work to do on this path at the intersection of transformation and reconciliation. I say we, as an immigrant myself, as I know many of you are as well. While Canada originally admitted its immigrants through the federal government, provinces now run their own immigration programs. I will provide some comments on these, but we'll start with a few words about my personal connection to immigration. My maternal grandparents fled Germany in 1933. My grandmother was released from prison after the Nazis came into power on the condition that she leave Germany immediately. My grandfather left an established family department store in Leipzig with just a suitcase, but like my grandmother, with his life intact. They ended up in South Africa, where they met, a country which took in Jewish refugees at the time. Canada, as documented by Professor Irving Abella in None is Too Many, was not as welcoming then as it is today. My wife, Lisa, too, has an immigrant story, but her grandparents were not as lucky. They perished after being deported from Brussels to Auschwitz. Fortunately, before being deported, Lisa's grandmother had the foresight to have her daughter Hélène, my wife Lisa's mother, hidden with Christian families in the countryside. By the end of the war, when Hélène was an orphan, Canada had opened the door more widely to Jewish refugees. For those of you who've been to the Pier 21 Museum in Halifax and seen the glass enclosed display of suitcases, Hélène's is one of them. Just 4 months after the establishment of the federal courts in 1971, Canada adopted its policy of multiculturalism to preserve the cultural freedom of individuals and provide recognition of the huge contribution of diverse ethnic groups to Canadian society. Immigration procedures were more lax in those early days. For instance, my father flew to London, England in 1976 from Durban. He explained to the Trade Commissioner that he proposed setting up a business in Toronto. Or he would use his green card to emigrate to Miami. Canada approved his application and he received immigrant visas 4 days later. That ended the Florida option, which I have never forgiven him for. Those more relaxed days of immigration did not last forever. The same year that we received our immigrant visas, Parliament passed the Immigration Act of 1976. Canadian immigration law took greater shape, in large part as refined through our jurisprudence at the federal courts. The development of today's body of Canadian immigration law largely coincided with the establishment of our courts, a theme that Professor Valois has eloquently eloquently documented in her chapter. As for another growth area in our immigration history, as I mentioned at the beginning of the presentation, the provinces have always been the direct beneficiary of immigrants who arrived from all corners of the world and contributed to Canada's unique diversity. It is unlikely that Canada would have resisted the expansionist tendencies of our neighbors to the south, but for our immigrants, including those who built our railway just after Confederation at the great personal cost to themselves, but to the great debt of our nation. During Canada's first century post-Confederation, our immigration levers lay with the federal government. A major shift came in that 1976 Act, which for the first time defined the objectives of Canadian immigration policy, included recognizing refugees as a distinct class of immigrants, and required the federal government to consult with the provinces on immigration planning and management. The 1976 Act also established the basis for much of today's statute, which we fondly call the IRPA. One other very significant change of the previous act was the provincial involvement in immigration. Now, nearly 50 years later, provinces and territories run their own immigrant selection programs. Quebec was the first province to form an immigration department in 1968 and became the first province to sign immigration agreements with the federal government, 3 between 1971 and the landmark 1991 Quebec-Canada Accord. All the other provinces and territories began to follow suit, starting with Manitoba 5 years later in 1996. These programs started with a trickle of immigrant selection under provincial nominee programs, but these PNPs now form a large component of our economic immigration program. For instance, Ontario was the last amongst the provinces to launch its program, starting with 150 nominees in 2006. But by 2020, just 15 years later, Ontario had selected more than 7,500 nominees, together with their dependents, over 15,000 immigrants. Multiply these numbers by all the provinces and territories, and we have a major program with about 100,000 new permanent residents being selected each year by the provinces, with categories running from students to farmers to innovators, tradespeople, doctors, and entrepreneurs. And the trend is once again expanding from the provinces to municipalities, which are increasingly involved in immigrant attraction and in their diversification. Rural areas need immigrants to build up and shore up population loss that has occurred due to urbanization. We are seeing smaller towns rejuvenating and remote regions attracting immigrants. In fact, discussions were recently launched for the adoption of a municipal nominee program. So every indication is that Canada will continue on its upward trajectory, and so too will our courts continue to become busier as entries increase in both the economic and non-economic streams, including surging refugee numbers from crises around the world, which of course reminds us all how very fortunate we all are to call Canada home. Bref, tout comme les cours fédérales ont créé un riche corpus de jurisprudence en droit d'immigration au cours des 50 dernières années, il y a tout lieu de s'attendre à ce que nos cours continuent d'être une voie importante pour les 50 à venir. Enfin, j'aimerais ajouter que nos trois experts ont joué un rôle déterminant dans le cadre d'un autre événement inaugural visant à célébrer notre 50e anniversaire, le concours de plaidoirie en droit de l'immigration, dont la première compétition a eu lieu au printemps dernier. Carl, un organisme fondé par Lorne Waldman, était notre principal commanditaire. L'équipe de l'Université de Montréal, dirigée par le professeur Valois, a remporté le plus de prix. Et en mars prochain, la juge Gleason jugera la dernière ronde de notre deuxième concours annuel. Alors, je vais maintenant céder la parole. Le professeur Valois va commencer, suivi de la juge Gleason, puis de Lorne Waldman. Nous aurons ensuite la période de 30 minutes de questions. Professeur Valois.
Merci beaucoup, Monsieur le juge Diner. Merci à l'Institut national de la magistrature et à la Cour fédérale pour l'organisation de ce webinaire. Et je vais faire ma présentation uniquement en français. Donc, ma présentation est divisée en plusieurs parties. Tout d'abord, je vais faire un survol des lois sur l'immigration depuis 1869, des changements importants qui ont eu lieu jusqu'à aujourd'hui. Je traiterai ensuite du contrôle judiciaire en droit de l'immigration. Il y a évidemment aussi une évolution de ce contrôle judiciaire-là. Je ferai un bref survol de jurisprudence importante qui ont été rendues par les cours fédérales concernant la définition de réfugiés au sens de la Convention. Ensuite, je discuterai du rayonnement des cours fédérales à l'étranger et je terminerai avec l'impact de la Charte canadienne des droits et libertés et le droit de l'immigration. Alors, j'ai préparé une présentation PowerPoint. Est-ce qu'on peut la mettre à l'écran, s'il vous plaît? Merci. Donc, prochaine diapositive, s'il vous plaît. Alors, c'est le plan de ma présentation en anglais. Donc, pour les fins du webinaire, il y a une présentation qui est bilingue, donc une diapositive en français, une diapositive en anglais, mais dans le cartable qui vous est offert comme participant, vous avez les deux présentations en français et totalement en français et totalement en anglais. Prochaine diapositive, s'il vous plaît. Alors, j'ai inscrit dans cette diapositive les principaux changements qui ont eu lieu en droit de l'immigration, les principales lois qui ont été adoptées, et je vais traiter brièvement de chacune de ces lois, jusqu'à la loi de 2001, la loi sur l'immigration et la protection des réfugiés, qui a aussi été modifiée, évidemment, après 2002, mais je vais arrêter à cette date pour parler du changement très important des changements très importants que cette loi a apporté. Donc, en 69, la loi sur l'immigration est plutôt courte. Les dispositions portent sur les obligations des commandants des navires qui transportent des immigrants, les devoirs des officiers concernant la quarantaine et la sécurité des passagers. Il n'y a pas à cette époque-là d'attente dans des bureaux d'immigration à l'extérieur. Les gens qui veulent immigrer au Canada montent sur des bateaux et espèrent pouvoir entrer au Canada. Le droit de passage s'élevait à 1 $ par passager âgé de plus d'1 an. L'histoire de l'immigration au Canada, c'est aussi l'histoire, malheureusement, de la discrimination à l'égard de certaines personnes et notamment à l'égard de l'immigration chinoise. Il y a eu plusieurs lois qui ont eu pour effet de restreindre de façon importante l'immigration chinoise. La première était en 1885. Le droit d'entrée pour les personnes d'origine chinoise était à 50 $ et non à 1 $. Et on limitait aussi le nombre de passagers qui pouvaient être transportés par bateau. Donc, seulement une personne pour 50 tonnes du poids du navire, alors que pour les Européens, le ratio était plutôt d'une personne pour chaque 2 tonnes de poids du navire. En 1900, le droit d'entrée a été augmenté à 100 $, en 1903 à 500 $, et finalement, en 1923, la loi interdisait complètement l'immigration chinoise, sauf pour les diplomates, les marchands et les personnes d'origine chinoise qui étaient nées au Canada. En 1906, on restreint aussi les conditions d'entrée au Canada pour certaines catégories de personnes, dont c'est exactement les mots qui sont utilisés dans la loi, les idiots ou les faibles d'esprit, les épileptiques et les pauvres ou nécessiteux. En 1919, on ajoute aussi à cette loi les dissidents politiques, les personnes souffrant de troubles mentaux et les illettrés. La loi autorise aussi le gouverneur en conseil à interdire l'entrée à certaines catégories d'immigrants en fonction de leur race, de leur occupation, de leur nationalité, de leurs coutumes et habitudes de vie ou même de leur incapacité à s'adapter. En 1947, il y a la première loi sur la citoyenneté canadienne. Et en 1952, une toute nouvelle loi sur l'immigration entre en vigueur qui donne d'importants pouvoirs discrétionnaires au ministre de la citoyenneté et de l'immigration d'accorder ou de révoquer des autorisations pour immigrer au Canada. Cette loi-là crée aussi la commission d'appel de l'immigration, l'ancêtre de la commission de l'immigration et du statut de réfugié, dont les membres sont nommés sur une base ad hoc par le ministre pour entendre les appels de certaines mesures de renvoi, et c'est le ministre qui décide si l'appel sera entendu par la commission d'appel de l'immigration. Le ministre a aussi le droit, en vertu de la loi de 1952, de révoquer les décisions de la Cour, de la Commission d'appel de l'immigration, et aucun contrôle judiciaire ne peut être exercé à l'égard des décisions du ministre, sauf si elles visent des citoyens ou des résidents permanents. En 1967, suite au livre blanc sur l'immigration qui prône l'élargissement des critères d'admission et l'élimination de la discrimination dans le processus de sélection, est publié. Ça fait suite évidemment aussi à l'adoption de la Déclaration canadienne des droits qui interdit toute discrimination basée sur la race, l'origine nationale, la religion ou le sexe. Et donc, c'est incompatible avec le maintien de politiques qui sont ouvertement hostiles à l'admission de certains groupes d'immigrants. En 1900, donc, il y a une nouvelle loi qui est adoptée en 1966 qui modifie la composition et la compétence de la commission d'appel de l'immigration pour la rendre plus indépendante des pouvoirs du ministre. Et c'est le gouverneur en conseil qui nomme les membres de la commission pour des mandats à durée déterminée. La commission a également le statut de cour d'archives et a une compétence exclusive pour entendre les appels des ordonnances d'expulsion et des décisions du ministre. La contestation d'une décision de la Cour d'appel, la commission se fait directement à la Cour suprême du Canada sur permission de celle-ci. Alors, en 1971, la Cour fédérale est créée, la section de première instance et la section d'appel. Le Parlement, dans la loi qui crée la Cour d'appel fédérale, modifie la loi et précise que c'est l'appel d'une décision de la commission sera à la Cour d'appel fédérale et sur permission également, au lieu d'être à la Cour suprême du Canada. En 1969, le Canada signe la Convention des Nations unies relative au statut de réfugié et donc s'engage à mettre en place dans la loi sur l'immigration un processus de reconnaissance du statut de réfugié. Prochaine diapositive, s'il vous plaît. Donc, le contrôle, comme je l'ai dit, le contrôle judiciaire est directement à la Cour suprême du Canada est remplacé par un contrôle judiciaire sur autorisation à la Cour d'appel fédérale. Et en 1973, la loi est amendée, la loi sur l'immigration, pour permettre à une personne durant l'enquête qui vise à déterminer si elle peut rester au Canada de demander le statut de réfugié au sens de la Convention. Et c'est à partir de ce moment-là que se développe une jurisprudence inédite sur le droit de l'immigration par d'abord la Cour d'appel fédérale, puis la Cour fédérale un peu plus tard sur le droit des réfugiés. Et c'est brièvement de cette jurisprudence dont je vais traiter maintenant. Évidemment, dans le chapitre 6 du livre sur le 50e anniversaire des cours fédérales, je fais une étude beaucoup plus approfondie et vaste des jugements qui ont marqué cette période. Donc, sur le contrôle judiciaire des cours fédérales, donc en 1971, c'est un contrôle judiciaire des décisions de la commission à la Cour d'appel sur une question de droit ou de juridiction d'abord. Par la suite, en 1976, c'est un contrôle judiciaire, évidemment, des décisions de la commission qui est un peu plus élargi. Il y a quand même quelques décisions qui peuvent aller devant la Cour, la section de première instance, mais pour ce qui concerne les décisions de la Commission d'appel de l'immigration, c'est sur permission à la Cour d'appel fédérale. En 1988-89, suite à l'arrêt Singh, la loi sur l'immigration est modifiée. On crée la Commission de l'immigration et du statut de réfugié qui a de vastes pouvoirs et qui doit tenir une audition orale pour toutes les demandes d'asile. Et donc, il y a évidemment, suite à ce changement-là, un changement à la Cour d'appel fédérale. Il y a un ajout à l'article 28 comme office fédéral, la Commission de l'immigration et du statut de réfugié, et toujours sur autorisation, et les demandes affluent. En 1993, le Parlement va transférer à la section de première instance la compétence qu'exerçait la section d'appel d'entendre des contrôles judiciaires de la SCSR, et ce changement va prendre effet immédiatement. Et donc, toutes les causes qui étaient déjà pendantes, certaines qui étaient déjà pendantes devant la Cour d'appel fédérale vont être immédiatement transférées à la section de première instance. Le contrôle judiciaire maintenant en Cour fédérale est prévu à l'article 72 de la loi sur l'immigration et la protection des réfugiés et permet, sur autorisation toujours, un contrôle judiciaire sur toute mesure, décision, ordonnance, question ou affaire qui est prise dans le cadre de la présente loi et est donc subordonnée au dépôt d'une demande d'autorisation. Prochaine diapositive, s'il vous plaît. Donc, la définition de réfugié au sens de la Convention, l'article 96 de la loi sur l'immigration reprend cette définition-là qui est celle de la Convention sur le statut de réfugié. Alors, c'est une personne qui, craignant avec raison d'être persécutée du fait de sa race, de sa religion, de sa nationalité, de son appartenance à un groupe social ou de ses opinions politiques, ce qu'on appelait les 5 motifs de protection de la définition, soit se trouve hors de tout pays dont elle a la nationalité et ne peut, ou du fait de cette crainte, ne veut se réclamer de la protection de chacun de ces pays. Soit, si elle n'a pas de nationalité, se trouve hors du pays dans lequel elle avait sa résidence habituelle, ne peut ni du fait de cette crainte, ne veut y retourner. L'alinéa B concerne le cas des apatrides. Donc, j'ai mis sur cette diapositive quelques jugements importants. Il y en a beaucoup d'autres qui ont été rendus par soit la Cour d'appel fédérale ou la Cour fédérale sur l'interprétation de cette définition qui peut être ambiguë sur certains aspects. Alors, dans l'affaire Rajuddin, on a interprété le premier paragraphe de la définition et on a énoncé qu'il y avait 2 volets, un volet subjectif et un volet objectif de la crainte de persécution qui doit être évalué par le tribunal. Dans l'affaire Oyarzo, sur la question de la persécution, il fallait évidemment définir la notion de persécution. On a jugé que le déni d'accès à l'emploi sur une période de plusieurs années à l'égard d'une personne en raison de ses activités politiques constituait de la persécution et que la Commission d'appel de l'immigration avait adopté une interprétation indûment restrictive de cette notion. Dans l'affaire Fossu, on a aussi interprété la notion de religion comme comprenant le droit, la liberté de manifester sa religion ou sa conviction tant en public qu'en privé. Et par l'enseignement, les pratiques, le culte et l'accomplissement de ces rites. Dans l'affaire Salibian, un jugement très important de la Cour d'appel fédérale où on a décidé qu'une situation de guerre civile, c'était le cas au Liban, où plusieurs groupes étaient ciblés, ne faisaient pas obstacle à une revendication, car la crainte du demandeur, même si plusieurs groupes l'étaient ciblés, n'était non pas celle entretenue indistinctement par tous les citoyens, mais fondée sur la persécution pour les motifs de la Convention. Et une autre affaire qui portait sur un demandeur venant du Liban, l'affaire Zalzali, où on a interprété la question de la protection de l'État, la capacité de la protection de l'État et on a décidé que l'absence de protection de l'État comprend la situation où en raison de l'effondrement total de l'appareil étatique, ce qui était le cas, celui-ci est incapable d'assurer la protection de ses ressortissants. Prochaine diapositive, s'il vous plaît. Donc, ces jugements et d'autres ont été commentés, appliqués de façon étendue par des juridictions étrangères, dont la Grande-Bretagne, en Nouvelle-Zélande, en Australie. Je vous ai mis deux causes parmi les nombreuses qui sont étudiées dans le chapitre 6, dont l'affaire Chan Yi-Kin en 1989, où le juge McHugh de la Haute Cour d'Australie cite les raisons dans l'affaire Oyarzo au sujet de la persécution et est d'accord avec la Cour d'appel fédérale que ça n'est pas restreint aux atteintes à la liberté ou à la sécurité de la personne. Dans l'affaire Hayden contre Secretary of State, c'est la House of Lords qui cite l'arrêt Salibian et qui établit que la persécution n'a pas à être, qu'il n'était pas nécessaire qu'elle soit individuelle pourvu qu'elle soit entretenue par au moins un groupe et qu'elle soit fondée sur l'un des motifs énoncés dans la Convention. Prochaine diapositive, s'il vous plaît. On ne peut parler de droit de l'immigration et de charte sans mentionner l'arrêt Singh contre Canada de 1985, où la Cour suprême du Canada a décidé que toute personne qui se trouvait au Canada avait droit aux protections offertes par l'article 7, quel que soit son statut au Canada. Donc, dans ce cas-ci, il s'agissait de 7 demandeurs du statut de réfugié qui étaient au Canada. Alors, l'arrêt Singh, évidemment, a eu un impact important. C'est ce qui a mené au changement dans la loi sur l'immigration pour créer la Commission de l'immigration et du statut de réfugié. C'était surtout, en fait, l'arrêt Singh n'avait pas décidé que tous les demandeurs d'asile avaient droit à une audition orale. Elle avait limité son jugement aux questions importantes de crédibilité et que la commission d'appel de l'immigration qui choisissait les personnes qui s'étaient vu refuser le statut de réfugié par le ministre et qui pouvaient avoir une audition complète devant elle, que c'était contraire, 3 juges ont décidé que c'était contraire à l'article 7 de la Charte canadienne et 3 juges avaient décidé que c'était contraire à l'alinéa 2 de la Déclaration canadienne des droits. Le législateur a quand même tenu à prévoir une audition orale pour toutes les personnes. Alors, je vais conclure rapidement. Prochaine diapositive. Évidemment, il y a eu beaucoup d'espoirs qui ont été fondés sur la charte. Espoirs qui n'ont pas été satisfaits, en fait, notamment parce que la Cour suprême a décidé dans l'arrêt de l'affaire Medoversky que l'article 7 ne protégeait pas contre l'expulsion du Canada.
Je pense, Martine, on va continuer avec les autres deux présentations.
Oui.
On va voir le temps, comme j'ai dit tantôt, pour l'audience à poser des questions. À la fin, professeur Valois, alors soyez à l'aise à envoyer les questions dans il y a un Q&A, une boîte Q&A, et puis on va maintenant commencer avec la juge Gleason.
Thanks, Justice Steiner, for your invitation to speak. And I'd like to thank the organizing committee established by the two Chief Justices who also invited me to produce the paper that you find in your materials and to deliver some brief comments to you today. And would also like to thank NJAI for their help in organizing the entire event surrounding the celebration of the 50th anniversary of the courts. I'll be speaking in both French and English, switching languages about halfway through my presentation, and then probably finishing up in English because I anticipate I may be short of time and can probably speak more quickly in English than in French. So turning to the presentation itself, I think I want to commence by noting that cases in the immigration and citizenship area are doubtless among some of the most significant heard by the Federal Court of Appeal. They've played a key role not only in immigration law, but in shaping administrative law generally. To name but a few, Baker, Pushpanathan, Agrera, and Vavilov come rapidly to mind, and they are, of course, leading authorities on various points in administrative law. They were all either immigration or citizenship cases. Baker, of course, setting out the law applicable to evaluate procedural fairness, Agrera, the appellate standard of review and judicial review, and Pushpanathan and Vavilov being in their respective eras, the leading cases on standard of review and judicial review. Despite the prominence of cases in the area, the Federal Court of Appeal actually hears relatively few immigration and citizenship cases, and the vast majority of cases in the area are decided finally by the federal court. This might come as a surprise to people who aren't familiar with this area of law, as one might assume the opposite, as I believe one of the professors presenting at the book launch noted. The few number of cases that wend their way to the Federal Court of Appeal is largely a result of the provisions in the legislation requiring a certified question to ground the jurisdiction of the Court of Appeal to hear an appeal from a decision of the federal court in an immigration or more recently in a citizenship case. The principal provisions are, of course, set out in paragraph 74D of the Immigration and Refugee Protection Act and 22.2D of the Citizenship Act. They provide that an appeal may only be made to the Federal Court of Appeal if, in rendering judgment, the federal court certifies that a serious question of general importance is involved and states the question. The provisions that are now in 74D of IRPA were first introduced in an earlier iteration in 1992 and 22.2D in 2014. For more detail on their history, I would refer you both to my paper and more importantly to the excellent chapter in the book authored by Professor Valois and her colleague Henri Beribaud. To ascertain the approximate number of cases heard by both courts, I undertook a decidedly unscientific inquiry because statistics aren't kept internally that would allow me to come up with an approximation. So I went to Canley and put in the words immigration and public safety in searches to see whether they appeared as a party name. Between 2004 and 2020, according to my search, there were 13,661 cases heard by the federal court, reported in Canley, where the word immigration appeared as a party name, and 1,499 where the term public safety appeared as a party name. There were likely several more immigration cases disposed of by way of order during those years that weren't reported in Canley. Publicly available data on the federal court's website indicates that 22,495 applications for leave were granted in immigration matters over the same period. However, they would not have all progressed to a hearing. Internal data from the federal court indicates that the federal court certified a question in only 468 cases in those years. Now, not all cases where a question is certified by the federal court end up in front of the Court of Appeal, as an appeal may not be launched, and even if an appeal is filed, some cases do not progress to a hearing. A similar search in Canley over the same time period indicates that the Federal Court of Appeal heard 270 cases where the word immigration appeared in the party name, and 76 where the term public safety so appeared. Some of these cases include situations where no question was certified by the federal court, and the Court of Appeal ruled on whether it possessed jurisdiction to hear the case. Although my method is certainly not scientifically rigorous, what it does show is that only a very small percentage of immigration cases find their way to the Federal Court of Appeal. With this background in mind, I'm going to now turn to discuss some of the case law regarding the requirements for a certified question, because the mere fact that the federal court certifies a question does not necessarily mean that the Court of Appeal will possess jurisdiction to hear the case. Rather, the case law establishes that the question must have been a proper one for certification before the Court of Appeal may exercise its jurisdiction. Through several cases, the criteria for a properly certified question have been established, and they're set out in much greater detail in the paper. The criteria were summarized relatively recently by our court in both Lewis, a 2017 decision, and Lanamila, a 2018 decision. To roughly paraphrase, the following are the relevant criteria. Number one, the certified question must transcend the interest of the parties. Number two, closely allied to the first, the certified question must raise an issue of broad significance or general importance. And three, the question must be dispositive of the appeal. The third point requires that the question have been dealt with by the federal court and that it arise from the case itself rather than merely from the way in which the federal court disposed of the application. In other words, an issue that need not have been decided cannot ground a properly certified question, nor can a question that is in the nature of a reference or whose answer turns on the unique facts of the case be properly certified. However, the Court of Appeal has also held that it's not constrained by the precise language of the certified question and may reformulate the question to capture the real legal issue presented. Tretz-Stitang, decided in 2016, makes this point, where Justice Rennie, writing in dissent but not on this point, stated as follows. As a general proposition, a question that cannot be answered will result in dismissal of the appeal on the basis that the right of appeal is contingent on a certified question having been properly identified. Nevertheless, the court's consideration is not constrained by the language of the question, and it may reformulate the question to align with the issue, as was decided by the Court of Appeal in Ezekola. Certification is merely a means by which appellate review is enabled, and the appeal is at large. As noted by Justice Rennie in the foregoing citation, once a question is properly certified, the appeal is at large and all issues may be considered by the Federal Court of Appeal and thereafter by the Supreme Court of Canada. While early cases from the Federal Court of Appeal held otherwise, the Supreme Court of Canada and Pushpanathan established that a certified question does not limit the scope of the appeal. The Supreme Court there noted that neither the Federal Court, Trial Division, nor the Court of Appeal had addressed the issue of the proper standard of review of the decision of the Convention Refugee Determination Division. The Trial Division's certified question asked whether its determination was an error of law, suggesting a standard of correctness. The Supreme Court held that the certification of a question of general importance is the trigger by which an appeal is justified. The object of the appeal is still the judgment itself, not merely the certified question. In that case, one of the elements necessary for the disposition of the application was the standard of review. And that question was a central issue in the case, and indeed formed much of the focus of the Supreme Court's reasoning. The Supreme Court found that the courts below had erred by not considering this question. Bearing these general principles in mind, I thought it might be useful to comment briefly on two of the several cases that are reviewed in the paper, which show how these principles have been applied. Le premier est l'arrêt dans l'affaire Canada contre Zazia, dans lequel la Cour fédérale a certifié une question qui n'a pas été considérée dans ses motifs. Selon la Cour d'appel fédérale, en procédant ainsi, la Cour fédérale invitait la Cour d'appel à trancher en premier lieu une question qui aurait dû être décidée par la Cour fédérale. Rédigeant les motifs pour la Cour, le juge Pelletier a expliqué que le corollaire de la proposition selon laquelle une question doit permettre de régler l'appel est qu'il doit s'agir d'une question qui a été soulevée et qui a été examinée dans les décisions de la Cour fédérale. Autrement, il s'agirait effectivement un renvoi à la Cour d'appel fédérale. Ainsi, si une question se pose eu égard au fait d'une affaire dont la Cour fédérale est saisie, il lui incombe de l'examiner. À l'inverse, si la question ne se pose pas ou si la Cour fédérale décide qu'il n'est pas nécessaire de l'examiner, il ne s'agit pas d'une question qui convient d'être certifiée. En application de ces principes, la Cour d'appel fédérale dans l'affaire Zazia a conclu que la Cour fédérale a erré en certifiant la question. Elle a annulé la décision de la Cour fédérale et renvoyé l'affaire à la Cour fédérale pour trancher la question qu'elle a omis de répondre. Le deuxième arrêt dont je veux faire référence est celle de l'affaire Mudrack contre Canada, où le problème s'inverse s'est posé et la Cour fédérale avait certifié des questions purement théoriques qui ne se posaient pas en l'espèce. Dans cette affaire, la Cour fédérale a certifié des questions suivantes en essayant de réconcilier les divergences contenues dans les décisions de la section de la protection des réfugiés traitant des questions reliées à la protection étatique en Hongrie. La première question était, la section de la protection des réfugiés commet-elle une erreur susceptible de contrôle si elle ne statue pas sur la question de savoir s'il a été démontré que les mesures en place dans un État démocratique pour protéger les minorités assurent l'efficacité concrète de la protection de l'État dans le but de conclure que celle-ci est adéquate. La deuxième question se lisait comme ceci. Les demandeurs d'asile sont-ils tenus pour obtenir la protection de l'État de porter plainte auprès d'organismes de surveillance de la police dans un État démocratique lorsqu'ils ne courent aucun risque de préjudice s'ils le font? La Cour d'appel a estimé que la première question n'était que théorique parce que la Commission avait fondé sa décision sur la conclusion de fait selon laquelle la preuve était insuffisante pour réfuter la présomption de protection adéquate par l'État et parce que le droit pertinent sur cette question était déjà bien établi dans la jurisprudence. En ce qui concerne la deuxième question, la Cour d'appel a conclu que la question n'avait pas été soulevée et était trop axée sur les faits pour constituer une question certifiée. Sur ce premier point, la Cour d'appel a souligné que la Commission n'avait pas tiré de conclusions défavorables du fait que l'appelant avait omis de déposer plainte auprès des organismes de surveillance, ce qui conférait à la question un caractère théorique. Il y a plusieurs autres exemples dans la jurisprudence où les critères applicables aux questions certifiées sont discutés dans mon texte. Je veux terminer en parlant brièvement de la jurisprudence de notre Cour traitant des exceptions aux exigences prévues par la loi pour se pourvoir en appel. Et pour ce faire, je pense que je vais retourner dans la langue de Shakespeare parce que, comme j'ai dit tantôt, le temps s'écoule. The case law recognizes that the Court of Appeal may have jurisdiction to hear an appeal in the absence of a certified question in a narrow range of circumstances, which were explored in the recent case of Canada, Citizenship and Immigration versus Tennant. There, Justice Laskin, writing for the majority, summarized such circumstances as including bias or a reasonable apprehension of bias on the part of the judge at first instance, a refusal to exercise jurisdiction, a separate divisible judicial act, which he explained as being a decision in the exercise of a power that arises not under the Citizenship Act or the IRPA, but from some other source. He then went on to discuss the concept of jurisdictional error, and I'll quote textually what he said on this point. At paragraph 38, this court has also used the term jurisdictional errors to describe errors that will permit an appeal to be heard despite a preclusive clause, and cites there Tisela Thuray. But it has also expressed reluctance to use that language, given the uncertainties surrounding the term jurisdiction in other contexts, preferring instead to use the language of fundamental matters, striking at the rule of law, and there cites to Majoub. In Tennant, the federal court had issued a directed verdict and affirmed that the applicant's grandfather was serving abroad as a crown servant at the relevant time, and that the applicant was a Canadian citizen as a matter of law. It declined to certify a question, although it was asked to do so. When the case was heard on the merits by the Federal Court of Appeal, a majority of the panel concluded that the Court of Appeal lacked jurisdiction to hear the appeal in the absence of a certified question. The minister argued that the federal court judge committed two so-called jurisdictional errors that ought to have permitted the appeal to proceed. These errors, the minister argued, were in impermissibly granting a declaration of fact related to Dr. Tennant's status as a crown servant, and in usurping the decision-making role of the minister under the Citizenship Act. In an earlier interlocutory motion where Justice Stratus allowed the case to proceed to a hearing before a full panel of the Court of Appeal, he expressed the view that the case law has not clearly defined the exceptions to preclusive clauses, such as paragraph 22.2d of the Citizenship Act. He sought to provide a clearer explanation for those exceptions and noted that the exception centered on jurisdictional errors was unhelpful because it would ultimately capture issues of statutory interpretation that were, at the best, mere errors of law. He proposed that the court should not give effect to preclusive clauses in two types of situations. First, where the federal court failed to exercise its jurisdiction in circumstances where it must exercise it, as would happen if the case turned on an issue but the court neglected to deal with it. And second, where there was a fundamental flaw going to the very root of the federal court's judgment, or striking at the federal court's very ability to decide the case, such as a blatant exceedance of authority obvious from the face of the judgment, an infringement of the rule against actual or apparent bias, supported by substantial particularity in the notice of appeal, which would give rise to serious concerns about the court's compliance with the rule of law.
Justice Gleeson, I don't want to be preclusive myself, but if we could hold off on that note, and I'm sure people will have some questions that they can put to you in the Q&A right after Mr. Waldman delivers his remarks on areas of unresolved law, shall we say, at the federal courts.
Well, I'll leave it. Thank you, Justice Steiner. And I'll leave it to readers to read what happened in Tennant. I'm sure many of the participants in this call know what the result was, and the Court of Appeal found it lacked jurisdiction, but the full reasoning of the court is set out there, as well as some other cases in the area. Thanks.
And I'll just add that the papers, both from Justice Gleeson and Mr. Waldman and Professor Valois' chapter in the book are must-read materials, some of the best things I've ever read on these topics. So I really commend them to you. Mr. Waldman?
It's an honor to have been asked to speak at this seminar commemorating the 50th anniversary of the federal court. And I'd like to thank the organizers, as have all my previous speakers. I speak today not only on my own behalf, but also in the name of all of my dedicated colleagues who represent refugees and immigrants before the different tribunals that render decisions in immigration matters. I began working in the refugee law area as a student in the mid-1970s, assisting persons from Chile and then Argentina who fled the dictatorships in their countries seeking a safe haven in Canada. Some of my clients had only recently escaped and still had the visible scars of torture that they had suffered. I met lawyers who were forced to run away to save their lives because they chose to defend political prisoners. I heard from my clients that when their lawyers applied for habeas corpus, the judges would turn a blind eye to what was happening. Some judges even collaborated in the human rights violations. I had clients who escaped from countries that had the best constitutions in the world that guaranteed that their rights would be fully respected under the law. But when my clients sought the protection of the law, the legal system failed them because most of the judges were under the control of those in power. Their testimony taught me how fragile the rule of law is, that we must be vigilant and constantly defend it, both here in Canada and abroad, and that the judiciary, and in Canada, the federal court plays a vital role in safeguarding our rights and freedoms. In my 40 plus years of practice, I have come before the federal court countless times seeking recourse for my clients. It's been a privilege to have been trusted by so many who have told me unimaginable stories of suffering, but have also showed me immense courage in the face of adversity. Most have limited resources. They don't speak English or French. They come from different cultures with different values, and they are often suffering from trauma as a result of the treatment they have endured. Each time I appear in court, I feel the challenge of having to convey the difficulties faced by my clients because their experience seemed to be so far outside the realm of what we see in Canada. Let me give you an example to highlight what I mean. The jurisprudence tells us that it is reasonable for a tribunal to draw an adverse inference from a significant omission from the original narrative filed in the support of a refugee claim. But imagine what one of my associates felt when her client followed her into the washroom just before the start of their hearing, breaking down in tears and telling her that she had been sexually assaulted by policemen in her home. She explained to my colleague that she had not been able to tell her what had happened because she had never been alone with her, and she could never reveal the assault to her husband because if he found out, his family would force him to divorce her. This was a significant omission. It was also a crucial piece of evidence, but it was one that counsel had been instructed not to disclose. Navigating a path out of that dilemma required patience and compassion, but the experience left us all wiser and reminded us again of how much we have to learn each day. Last week, I once again was reminded of how little I know. I was privileged to be asked by a close friend, a lawyer who represents Indigenous peoples, to assist him by examining an expert at trial. During the course of her testimony, she spoke briefly about how her family had been devastated by the residential schools. I realized I could never, ever understand the hurt and damage that had been caused by our government's inhumane system that took the lives of so many innocents. As such, we have our own history of denying the horrors that have happened. After all, our former prime minister, who was Minister of Indian Affairs while the residential schools was still in existence, recently stated he was never made aware of the abuses. See, before a tribunal, my client's history of abuse is found not to be plausible. They should remember that we in Canada denied for years this systematic violence that our government inflicted on defenseless children, and only now are we barely beginning to make reparations. Given all of this, the supervisory role played by this court is crucial in ensuring that all Canadians, and in particular Indigenous people, immigrants, and refugees are treated fairly. The court has rendered many decisions which have had a dramatic impact on the rights and lives of immigrants. For example, in Hasuna, the court struck down legislation which allowed the minister to revoke citizenship without a hearing. In Resolved, it certified a class action that allowed over 100,000 applicants to have their application for permanent residence considered after they'd been unlawfully terminated. And in Canadian Doctors, it determined that denying healthcare to refugees was a violation of the Charter. Since I first started working as an immigration lawyer, I've watched as the national immigration practice has grown from a handful of members into a flourishing bar. I've also seen the transformation in the way the federal court adjudicates immigration and refugee cases, and I've witnessed the development of a sophisticated jurisprudence in this area. When the Federal Court of Appeal was created 50 years ago, judicial review in immigration matters was heard by the Federal Court of Appeal under Section 28 of the Federal Court Act. And the Court of Appeal continued to hear immigration matters until the early 1990s. As the United Nations Convention relating to the status of refugees was only formally implemented in Canadian law under the Immigration Act of 1976, the earliest jurisprudence in refugee law was written by justices of the Federal Court of Appeal sitting on judicial review. In those days, we didn't have quick law or easy access to foreign jurisprudence. The only resource for many years was the UNHCR handbook, which was often cited by the court in those early days. That didn't prevent the court in the 1980s and 90s from deciding AGI, which determined the standard of risk to be applied when determining whether a refugee is a well-founded fear, Rajadine, which discussed the meaning of persecution, Ramirez, which discussed exclusion under 1FA. The Supreme Court's decision in 1985 in Singh determined that refugees had a right to an oral hearing when credibility was an issue. This made full-scale reform of the refugee determination system necessary, leading to the establishment of the Immigration and Refugee Board. When the board was created after the legislative amendments were introduced, which gave the federal court supervisory jurisdiction over immigration issues. The Immigration Act was also modified so as to require leave for judicial review and also to restrict appeals to the Court of Appeal on certified questions. And here's is where we now talk about the 10 unresolved mysteries. The introduction of the requirement for a certified question has placed serious limits on access to the Court of Appeal by applicants. Undoubtedly, the certified question requirement has prevented the Federal Court of Appeals docket from becoming overwhelmed, but at the same time, it has a negative impact on the development of immigration law, as a restriction of the right of appeal has left many issues unresolved. The lack of a definitive position on issues that arise in immigration practice has put applicants for immigration status in a difficult position. Uncertainty in the law means that first-level administrative decision makers can arbitrarily select the thread of jurisprudence that suits them. It also means that applicants cannot be certain as to which position will be adopted by a specific decision maker in a specific case, since the state of the law is often not knowable in advance. In response to the seemingly inconsistent threads in the jurisprudence, justices of the court have over the years written decisions which have attempted to reconcile them. A recent example being Sendaharajay, where the court tried to reconcile two lines of cases regarding cooperation. Although there are other options available when there is an ambiguity, such as jurisprudential guides, and one was recently issued by the chairperson. There are many cases where the law is unsettled. In the paper that I've written, I've chosen to write about some of the areas in immigration and refugee law which are unsettled, and it's my hope that by discussing these issues, I can continue the ongoing dialogue between the Immigration and Refugee Bar, the government, and the court. In the paper, I wrote about 10, but given that I think I have about 3 or 4 minutes left, or 2, I'm not sure, I can discuss only a few of them in the remaining time. So let me start with one, the notion of subjective fear. There are 2 trends in the jurisprudence. Some decisions say that a finding that a refugee failed to claim elsewhere or delayed in making a claim can be relied upon to make a finding that there's no subjective fear. And this in and of itself can be the basis for refusing a claim. So I've seen cases where the tribunal says, refugee has no subjective fear, case dismissed, and the federal court has upheld it. But there's another line of cases, which I think in my respectful submission is the correct one, that indicates that a finding of lack of subjective fear is in reality a credibility finding. Think about it. If you say, I don't believe the refugee because he delayed in making a claim, what you're really making is a plausibility finding. It's not plausible that this refugee fleeing a persecution wouldn't have made his refugee claim immediately. or if a claim claim wasn't made in the first country, it's not plausible that that refugee wouldn't have made the claim in the first country. So findings of subjective fear are inevitably credibility findings. And the jurisprudence of this court has taught us that plausibility findings especially should only be made in the clearest of cases. So then there's a second issue, which I could discuss. And I think perhaps that might be as far as I'll have time-wise looking at the clock. There's the issue of the scope of discretion of the minister delegate under section 44.2 of IRPA. So this is when the delegate decides whether or not to refer a matter to an admissibility hearing. This is an important issue. Permanent residents who are found inadmissible for serious criminality and received a sentence of 6 months or more don't have a right of appeal to the Immigration Appeal Division. So the only place where an official will decide whether or not there are sufficient humanitarian grounds to warrant not proceeding with removal is at this stage. Yet the scope of the minister's delegate's discretion is unclear. Some cases say there's no discretion. Others say that the delegate has a limited discretion to consider equitable issues. Others still say that the delegate can consider equitable factors, but if they decide not to, it's not an error. So where does that leave me when a client comes in with a letter from the minister's delegate saying you have an opportunity to make submissions? I have to explain to them that although they've been invited to make a submission, the delegate is under no obligation to consider them, but they might. And if they do, they may take them into account, but if they don't, it's not an error. But if they do take it into account, they have to consider all the evidence. The person is left deciding with whether or not to expend their limited resources on such an uncertain process without knowing whether their submissions will actually ever be considered. What if the regime of a refugee claimant who comes from a regime that doesn't respect the rule of law? Under the refugee claim, he can consider can challenge the validity of their conviction and show that the conviction was unfair. But if he's referred to an admissibility hearing, the jurisprudence says that there's no possibility of going behind the conviction and he would be found inadmissible. So we have a case, in fact, where a person was found to be a refugee because the Refugee Protection Division found that he didn't commit the crime or he didn't get a fair trial, but he was still found inadmissible and the inadmissibility finding was upheld by the court. The implication for this is maybe the result may be the necessary implication of the wording of the legislation, but surely it'd be an abusive process for the minister to rely on evidence of a conviction from a regime that doesn't respect the rule of law or comply with charter values. To conclude, immigrants and refugees make a vital contribution to our society, but they are vulnerable and can easily be subject to exploitation. In the name of the hundreds of immigrants and refugee lawyers across the country, I can say that it has been an honor and a privilege to have appeared before this court so many times, each time as an advocate for my clients' rights. Each of us, counsel for the applicants, the respondents, and the courts have an important role to play in ensuring that the most vulnerable are treated fairly. I look forward to many more years of dialogue where I will continue to do my best to represent my clients. Thank you very much.
Thank you very much, Mr. Waldman, and all the panelists for your excellent presentations. And thank you for the two questioners, Mr. Clark and Mr. Martin. So let's start with a last question that we received from Mr. Martin, and then I'll respond to the next one from Mr. Clark, which is, do the speakers feel that the enactment of Section 97 froze the development or interpretation of the Convention refugee definition? And I'll ask Mr. Waldman if he has any comments on that, and then Professor Valois, if she has any comments on that question.
On the contrary, I think it was an extremely important decision to include in the legislation protection against the right to be free from torture and cruel and inhumane integrated treatment. I think that, in fact, there's been very limited discussion of of the notion of cruel and inhumane integrating treatment or cruel and unusual treatment. And I think it's very important that we start looking more closely at it. And just one brief comment on that. I had something in my paper that I took out because I didn't have time. And that's this whole notion of there being different standards of proof for refugees as well-founded fear. But in the case of risk of torture, it's a balanced probabilities. This is hugely problematic, and I think that it's something that we're going to have to find a way to get that up to the Court of Appeal so that they can reconsider it. And that the whole problem of getting something to the Court of Appeal through a certified question is another issue.
Et professeur Valois, avez-vous des commentaires sur cette question?
Oui, je suis d'accord avec M. Wallman que non, l'ajout de l'article 97 était un développement très important. Vous savez, les modifications à la loi sur l'immigration, certaines sont positives, d'autres moins positives. Celles-ci sont venues en 2001 justement pour, si on veut, pas contrecarrer, mais répondre au fait que des jugements de la Cour fédérale rejetaient des demandes d'asile où il y avait réellement des risques pour les personnes, des risques pour la vie et la sécurité, parce qu'on ne pouvait pas trouver de lien avec l'un des 5 motifs de la Convention, dont les cas de violence généralisée, de criminalité généralisée dans certains pays. Alors, l'ajout de l'article 97 a permis de permettre justement à ces personnes de rester au Canada et d'obtenir la protection et aussi d'obtenir le statut de personne protégée qui venait s'ajouter au statut de réfugié au sens de la Convention. À mon avis, ce qui a freiné d'une certaine façon le développement de la jurisprudence des cours fédérales sur le droit des réfugiés, c'est cette habitude qu'a pris la section de protection du réfugié de décider la plupart des causes sur des questions de crédibilité. Et comme la jurisprudence sur le contrôle judiciaire fait en sorte que les questions de fait sont du ressort du tribunal administratif, évidemment, la déférence que les cours fédérales doivent avoir à l'égard des conclusions de crédibilité a fait en sorte que ça, à mon avis, un peu sclérosé le développement du droit de l'immigration comme il avait été développé dans les années 90 principalement.
OK, merci bien. Alistair Clark asked a question, if I can find my Q&A screen, which was regarding the distinction between Quebec. I'm sorry, I don't see the screen right now, but the question was roughly, I had mentioned that Quebec provided in its immigration accord that it would be involved. It created a selection program for immigrants. And then I said that the other provinces followed suit. Thank you. I see that now. Followed suit. And Mr. Clark says this seems to imply that Quebec had the first PNP program. My understanding was that the Manitoba PNP program was the first one in Canada, which is correct. Mr. Clark, you are correct. Manitoba's was the first PNP program in Canada. Quebec's was a broader accord than what was contained in the other provincial agreements. When I said that they followed suit, I just meant that they followed suit, the provinces, with the selection of immigrants. Until then, the province had not been selecting or properly termed nominating immigrants, because there is a slight distinction in that term, at least in the legal language of the agreements, between the Canada-Quebec Accord and the nomination agreements that all the other provinces and territories have. And so I simply meant that they followed suit in choosing immigrants that they wish to select to come to Canada, which has grown to over 50% of economic immigrants and was well below that when Quebec started in 1991. And so there are distinctions if you want to look precisely at the 1991 Quebec Canada Act. It's in section 12 where the powers of selection are enumerated, and in the provincial agreements, if you want to take two as an example, in the PEI agreement, section 7 outlines what the powers mean to PEI. In Ontario's agreement, most recent agreement, there's been a couple, but it was in 2017 that the most recent one, which sets out Ontario's powers. I don't want to get into the distinctions because I'm asked to adjudicate on these matters, and I recently issued 2 interpreting these kinds of clauses. but essentially there is a difference if you look at the agreements on those powers. And so I'll let you see the distinction by referring to those, the actual agreements, which I referred you to, and I think you will see the distinction laid out there. Not to leave Justice Gleeson out, I have a question for her, and then I do have a couple of other questions for the other panelists. So Justice Gleeson, let me ask you, please. You mentioned that the majority of cases and the numbers were quite interesting in your talk, that there's a distinction in the numbers of cases being heard by the FCA and the fact that there are, in the grand scheme, relatively few. So given the big importance when you do get before the FCA as an immigration counsel, and I know a lot of them are on the line, do you have any tips that you'd like to share us about appearing before your court?
Thank you for the question, as they say on TV, Justice Steiner. I think the tips I would give for advocacy in immigration cases before a court are very similar to the tips that would apply generally to advocacy, although maybe make emphasis on a few points. I think it would be worthwhile for counsel to have a look at who their panel is. And I know we do let people know who they're appearing in front of before they show up in the courtroom to get a sense of what the panel's experience is in immigration matters and how recently they've come to our court from the federal court if they were on the federal court. I think it's helpful, bearing that in mind, to maybe give a bit more context and background to the panel, both in your oral submissions and indeed in written submissions before you know who the panel is going to be, to try and situate the particular question that the court's being asked to deal with in the overall architecture of the legislation and the overall jurisprudence in connected kinds of issues. Sometimes things are dealt with too microscopically, and it might be more useful to sort of give a bit of a sense of the overall way something fits into the architecture of the Act. I'd emphasize again how important excellent written submissions are in front of every court, but particularly an appellate court where your time to speak is very limited. And so the excellence and the thoroughness of the written submissions being really important. The accuracy of the references being really important too. All the work that the junior lawyers on the call spend their time doing is vastly important to the rule of law and to the court's ability to fully understand all the applicable jurisprudence. So putting in all those pinpoint sites and getting the paragraph references right, really important as well.
Thank you. Mr. Waldman, I will turn to you now with two questions. One that had come in that you may see on the Q&A from Mr. Langlais in Montreal. Whether you can summarize your thoughts on one of the unresolved questions, establishment and misrepresentation, the double counting debate. And Hugh, I would also urge you to read that section. I forget which of numbers 1 to 10 it is, and Mr. Waldman can tell us, but he has written extensively on that question in his paper.
Very briefly, the position, I mean, there's two lines of thought, right? And one line of thought says that if you misrepresent, you didn't deserve to be in Canada, so we shouldn't count your establishment. The other line of thought says, or case law says, no, you're being removed for the misrepresentation, ergo, that's one factor that gets balanced. That's the reason why you're being removed, and that gets balanced against everything else. It gets balanced against establishment, remorse, best interests of the children, hardship upon return. And so the double counting comes in if you discount the establishment because of the misrepresentation. So there's two lines of cases. And in my respectful view, the line that says that you balance the misrepresentation against the other factors is more consistent with the decision of the Supreme Court of Canada cheer the test set out in the jurisprudence. So that's my take on that.
Thank you. And yeah, you provide a very detailed explanation in your paper. So the second question I had for you is, given the fact that the common law is constantly changing and the Supreme Court has acknowledged that there are exceptions to the principle of stare decisis, does the fact that an applicant can only appeal to the Federal Court of Appeal if there's a certified question limit, in your view, an applicant's ability to challenge established precedents? And if that's the case, then what would your advice to counsel be to deal with this hurdle, I suppose, that applicants may need to get over?
Yeah, well, the issue is pretty clear. Federal Court of Appeals made a decision. I'll take one example that's close to me now because I'm trying to figure out how I'm going to get it back to the Court of Appeal. It's a case called Lee. It was decided in 2005, where the Federal Court of Appeal said that the standard of risk that's applied when you're dealing with risk of torture is a balance of probabilities. So when the Federal Court of Appeal decided that in 2005, it was the international jurisprudence on that particular issue wasn't very well developed. Since that time, there's been a lot of consensus that that's the wrong standard. The standard of risk for torture should be the same as the standard of risk for well-founded fear. So the dilemma that we face is, how do we get that back up to the Court of Appeal? Because how can a judge of the federal court certify a question when there's a contrary opinion already at the Court of Appeal? And so that's the barrier. And I suppose the way around the barrier is to take it on directly, argue that Bedford allows the court to reconsider established jurisprudence in certain exceptional circumstances, and put forward a case that there are exceptional circumstances. And what those might be in this case would be a general consensus under international law that the correct standard is something other than the balance of probabilities. But obviously, having the hurdle of a certified question is just one additional barrier to trying to get the court to reconsider established precedent, and it creates an additional hurdle and step. But I don't think it's insurmountable. You make the argument at the first tribunal, and you hope that they'll consider it. And if they don't consider it, you argue that their failure to consider it based on Vavilov is a reviewable error. And then you try and get the federal court to consider it and try and convince the judge that you meet the test for stare decisis to be overturned on the particular case.
Thanks, Mr. Waldman. I will turn with another question to Professor Valois, and then I see, but I have not yet read, that a new question has come in, which I'll do in a second while you're answering. This question concerns, you raised during your presentation that many of the early decisions were made by the Federal Court of Appeal, naturally because the Federal Court of Appeal was the first stop in the immigrant's journey in the judicial system after a refusal below. And so my question for you is, do you believe that this jurisprudence has been fully utilized, this early Federal Court of Appeal jurisprudence has been utilized fully by the immigration refugee bar? Si vous croyez que la jurisprudence de notre temps, dans les années 90, pas 90, mais the 90s, a été utilisé suffisamment par le barreau d'immigration?
Oui, justement, non, je crois que non. Et c'était une des raisons pour lesquelles j'ai choisi de discuter abondamment de cette jurisprudence dans le chapitre. Évidemment, parler du droit d'immigration devant les cours fédérales depuis 1971, j'aurais pu écrire le livre en anglais, 730 pages. Nous devions nous limiter à 25 pages et finalement, j'en ai fait au moins le double pour ce chapitre. J'aurais pu traiter de beaucoup d'autres sujets de la compétence des cours fédérales, mais j'ai choisi de parler de cette jurisprudence-là innovante dans les années, fin des années 70 et 80, de la Cour d'appel fédérale sur la définition de réfugié au sens de la Convention, une définition qui est ambiguë avec plusieurs notions très larges, comme la notion de persécution, de crainte avec raison. Et j'ai constaté qu'il y avait beaucoup de jugements de la Cour d'appel fédérale qui avaient été presque ignorés dans les années 2000 et que il fallait retrouver cette jurisprudence-là qui n'est pas disponible la plupart du temps sur Canly et sur le site de la Cour fédérale parce que ce sont des décisions qui sont rendues avant les années 90. Elles sont disponibles la plupart sur les sites comme Quick Law où quand même il y a des frais importants pour avoir accès à cette jurisprudence-là. Mais je pense qu'il faut revenir à ces jugements-là qui adoptaient des interprétations très larges de la définition de réfugié, de la question de la protection de l'État. Et je pense que le barreau le barreau plus jeune, alors Maître Waldman et nous sommes du barreau plus âgé, pourrait bénéficier de cette jurisprudence-là.
Merci bien, professeur Valois. C'est une bonne idée d'étudier les anciennes arrêts et causes aussi, et pas juste les nouveaux.
Et aussi parce que la Cour d'appel fédérale, les jugements font encore jurisprudence et lient la Cour fédérale dans un certain sens.
Et finalement, on a juste le temps pour une dernière question qui vient encore une fois de M. Langlais. Et la question, c'est on habeas corpus decisions, what is the appropriate forum? Again, Mr. Langlais, you're choosing another topic on Mr. Waldman's list. I think I read that topic, but in any event, it's still one that has some uncertainty to it. But why don't we get anybody who wishes to jump in for just 30 seconds, because that's all we have at this point.
Well, I mean, the federal court doesn't have habeas corpus jurisprudence jurisdiction, so you can't do that. Recently, I tried something new, and I basically filed an application for a declaration that the detention was illegal and wanted to have it expedited as a sort of an alternative to a habeas corpus in the Superior Court. I guess one would wonder why you would do that if you can go right to the Superior Court. But the habeas corpus jurisdiction is only in the Superior Court. The question is when you should go there. That's a whole other discussion that we can't just debate in 30 seconds.
All right. Well, I'm sorry, Mr. Langlais, we don't have that time, but I'm sure Mr. Waldman would be gracious enough to have an offline discussion with you to further explore your question. And obviously, there is the Supreme Court case in Chima, I think it was, and where this was discussed at length, and other case law from the Ontario Court of Appeal, Chowdhury and the like. In any event, we will end the session now, but before we do, please just let me say a couple of final remarks, and that would be that we hope you've enjoyed this brief glimpse into the work of the federal courts in the matters of immigration. And throughout the coming months, we will present an additional 2 webinars addressing issues that touch on national security and intellectual property. Au cours des prochains mois, nous présenterons 2 autres webinaires sur des questions qui portent sur d'autres domaines de nos travaux, la sécurité nationale et la propriété intellectuelle. Soyez des nôtres. Le lien vers le formulaire d'inscription est dans la boîte de discussion. The registration link for these 2 other webinars is in the chat, and we do hope that you will join us. Have a great weekend, everybody. Bon fin de semaine à tous. Merci.